Hi, this is Matt with Learn About Law. Today we're diving deep into the world of restrictive covenants in Illinois for 2023. Whether you're an employer navigating these agreements or an employee trying to make sense of it all, understanding the ins and outs is key to this ever-changing legal landscape. So what are restrictive covenants? Essentially, they're those legal agreements between employers and employees that put limits on what an employee can do after leaving a job. We're talking about non-compete and non-solicitation agreements here. And let me tell you, things have been shaking up in the legal scene lately. Starting on January 1st, 2022, the game changed. Now, whether these legal covenants hold water depends on how much the employee makes annually. It kicks off at $75,000 and climbs by $5,000 every 5 years until it hits $90,000 in 2037. Of course, there are exceptions, like deals tied to selling a business or ending a partnership. Employers, you've got to keep your finger on the pulse and watch out for advice from the Illinois Attorney General. Non-compete agreements are like the gatekeepers of post-employment competition. They stop former employees from jumping into similar gigs that might hurt their ex-employer. In Illinois, these agreements can work, but they need to be reasonable in terms of time, scope, and location. Drafting them right is crucial for employers looking to protect their interests. Now, non-solicitation agreements are the bouncers at the client or customer club. Employees can't just waltz in and poach clients for themselves or a competitor. Again, reasonability is key here. And both employers and employees need to pay attention to the details, like salary bumps or bonuses, to make these agreements rock solid. The Illinois Freedom to Work Act has also thrown its hat into the ring. If you're in financial services, this one's got some rules and regulations for your restrictive covenants. Employees even get the green light to claim their attorney's fees if they win a court battle against their employer over these covenants. Big changes, right? But here's the kicker. It's not just about numbers and rules. We're talking about the heart of these agreements, consideration. That's what makes them tick. It could be 2 years of post-agreement employment or some good old compensation. And if you're on the lower wage side, earning less than $13 an hour, you've got your own standards. Employers, take note. These considerations are your ticket to enforceability. When it comes to enforcing these covenants, it's the courts that hold the reins. They've got some criteria like being attached to a valid employment relationship, given written notice, and allowing a 14-day review period. Non-solicitation agreements kick in once the employee's expected annual earnings hit $45,000. And if there's a breach, brace yourself for injunctive relief, damages, and attorney's fees. Now, let's talk real talk. Reasonableness is the name of the game. These agreements need to fit like a glove, considering time, scope, and geography. And that's not all. Protecting trade secrets and confidential info is crucial. Encryption, access restrictions, and policies, that's the secret sauce. Recent legal shakeups, court decisions, and amendments in 2021 have kept things interesting. Employers and employees, you've got to be on your toes, understanding your rights, obligations, and the ever-evolving legal landscape. In a nutshell, restrictive covenants in Illinois in 2023 are a balancing act. Employers and employees need to stay informed, work together, and find that sweet spot that safeguards business interests while fostering a fair and competitive working environment. It's a dance, and knowing the steps is half the battle. Thanks for watching. To learn more, check out the article links below. Be sure to leave any questions you have in the comment section and subscribe for more legal news daily.